So hello guys, what's up and welcome back to my YouTube channel. It's me, your girl Barrister Neze, and this is Nezeville. It's been 2 months now since Omodesola Whitney Adeniro passed. Omodesola was a 12-year-old ex-student of CHRISLAND schools. She set out on this fateful day for the school's inter-house sporting competition. She left healthy, strong and young, but before the end of the day, she was dead. The school tried to pass the narrative that Omodesola had just slumped and passed, a narrative that her parents were not having. And despite several appeals to the school, they insisted that there was no more to say. Her parents had no other option but to conduct an autopsy on their child. The post-mortem result revealed that Omodesola did not just slump and pass, but she passed from electrocution. Angered by the whole situation, especially the school's concealment of the truths of that event, her parents have sworn to go to the ends of the earth in search of justice for their child. In today's video, guys, I'm going to be updating us on everything that has happened after our last video, and down in the description box I'm going to leave a link of all the videos I've done regarding this case so you can catch up. The first major update that has happened in this Omodesola case is that the Director of Public Prosecution has established that there is a prima facie case against the school. So when a case is brought to the police from the police station does not just charge the matter straight to court. The matter has to pass through the Director of Public Prosecution. That is the office that prosecutes criminal offenses for the government, for the state. Let us not forget that criminal offenses are offenses against the state. So an individual does not even have a right to say, oh, I don't want to charge this person for murder. Hello, it is not your case. Criminal offenses is an offense against the government. It is civil offenses such as breach of contract, trespass, and those kind of things that you are at liberty to choose whether you want to go to court or not. So what happens is that the Director of Public Prosecution will go through the details of the case and establish whether there is a prima facie case, whether there is any need at all, whether with all the evidences available, the state stands a chance of winning such a trial in court. So if the Director of Public Prosecution, let me just call it DPP, if the DPP reviews the case file and finds that the case is not weighty, that there's no chance in court, or there are not enough evidences, or it's a trivial or malicious case, then the DPP would push it aside and say there's no prima facie case. But the DPP has gone through the file of Omodesola and has established that they have a strong case in court. And the office of the DPP have also revealed that the school, 4 members of staff, and the vendor at the Agege Stadium will be facing a criminal trial. They will be charged with the offenses of involuntary manslaughter and criminal negligence. Well, I very well expected that charge. I wasn't expecting a murder charge because there was no intent. Remember that on a video that I just put out some days ago, I explained the intention and how it plays out in the kind of charge that can be brought forth against somebody. So even if there was a loss of life, there was no intention to kill. In fact, listen to this quick clip from the video I put out explaining this in detail. Now, for anybody to be held liable for the offense of murder, 2 very important ingredients must be proven. One is the mens rea, that is the intention to kill. And the second one is the actus reus, which is the act itself that caused the death. So there must be the action that caused the death, and there must be intention to cause death. Those 2 fundamental ingredients must be present before you can even charge or convict somebody of murder. So if a hunter is in the forest, for example, hunting, and he sees a deer and he shoots at it and kills it, obviously he lacks the mens rea. He lacks the intention to kill a human being, right? But the action of killing was present, which is the actus reus. So that hunter cannot be charged for murder because those two must be present. One cannot be left out. But where the mens rea is absent, when the intent is absent, then that person can only be charged and convicted for a much lesser crime, the crime of manslaughter, whether voluntary or involuntary. Involuntary manslaughter under the law occurs when one lacks the intention to kill but has caused the death of another through recklessness or criminal negligence. So the punishment for murder in Nigeria is death, outright execution. But in the case of involuntary manslaughter, with a fair trial and a lenient judge, such a person should be looking at between 2 to 6 years. So that is why they are being charged for involuntary manslaughter and criminal negligence, because there was no intention to cause her death, but due to not exercising their duty of care, a life was lost. So on the 30th of March, the case began officially in court, and CHRISLAND schools and 4 others were arraigned before a high court in Ikeja for the involuntary manslaughter of Whitney Adeniro. They all took their pleas and they all pleaded not guilty. I had also explained what a plea is. Listen to this clip, very important. An arraignment signifies the official opening, commencement of a criminal trial. It is the official reading of the charges on the criminal trial sheet to the defendant or to the accused, so he would understand why he is on trial. He will understand the charges that have been levied against him. It is mandatory in every criminal trial, and failure to do that renders both the whole proceeding and the outcome of it completely null and void. So the process involves calling the accused person by their names, their full names. Answer your papa name. Yes, that's where it comes from. And the charges will be read to him in full in a language that he or she understands. Very pertinent. And then he or she will be required to take a plea, to make a plea. You can either plead guilty or not guilty. If he or she pleads guilty, good and fine. It makes everything easy, fast, and closure comes easily. It brings us closer to straight up sentencing. But if he or she pleads not guilty, which is more often the case, then the trial can now begin in earnest. So the 4 people that were arraigned was the principal, one, Mrs. Amao, the vice principal, Mrs. Nwaltu Victoria, a teacher at the school, Mr. Kuku Fatai, and a vendor at the Agege Stadium, Mr. Ademoye Adewale. It was indeed a very sad sight seeing the principal break down in uncontrollable tears when she was docked. I don't think I've explained to you guys what it means to be docked. When you are docked is when you are put inside that box in the court. There are 2 boxes in the court. One of the box is a witness box, where you are to stand as a witness and testify before a court, and the second box is the accused box, also known as the dock. So when you are accused and you want to take your plea, whether you're going to plead guilty or not guilty, you will stand in the dock. It's compulsory. It is compulsory to stand in the dock. So the principal was there in the dock, and they read her offenses to her, and she was asked to take her plea, and she was weeping, wailing profusely. It was touching to a lot of people. These 4 people risk a good number of years in jail time. The prosecution had informed the court. Prosecution, those are the people that are prosecuting CHRISLAND. That is the state government, the Lagos state government. Yes. So the prosecution had informed the court that they will be calling upon 17 witnesses for their case against CHRISLAND schools and the other 4 accused persons. I envisage a very, very strong legal battle on this case, because even CHRISLAND schools have a very seasoned team of lawyers defending them. They have about 4 sons, senior advocates of Nigeria, in their legal team, amongst other lawyers. It's going to be tough. Another thing that has happened is that all 4 accused persons have now been granted bail. So they are no longer in police custody or prison custody. They are now at home. So in law, there are 2 types of bail. There is the police bail and there is the court bail. The police bail is granted by the police, and it is granted before the case goes to court. So when there is a crime has been reported to the police, and during the course of the police's investigation, they need to detain people. They pick up these people, and these detained people can seek for the police to grant them bail. But immediately the case is instituted in court, the police loses the the right, the authority to grant bail, and it becomes fully within the discretion and the jurisdiction of the magistrate or the judge to grant bail. It now becomes court bail. So the kind of bail that has been granted to these people, CHRISLAND Schools and its staff, is court bail. And a good number of people are quite enraged as to why the court should grant them bail. They believe that this offense is serious. A child died, somebody passed. Bail should not be contemplated, talk less of being granted. They believe that these accused persons should have been remanded in prison custody throughout the trial. So before I give you what the law has to say about this, let me get your thoughts in the comment section. Do you think that these accused persons, it's okay if they go home and attend their trial from home, or do you think that they should be confined within prison custody? Let me know what you think, given the severity of the crime and the mental state of the family of the deceased person. So the law says that generally all offenses are bailable except capital offenses. Capital offenses are offenses that attract the death penalty or life imprisonment. Offenses like murder, rape, kidnapping, terrorism, and things like that. So aside from these kinds of offenses, every other offense is bailable according to the law. But note that the right to grant or deny bail is strictly within the jurisdiction and the discretion and prerogative of the magistrate or the judge that is hearing that case. So even if you have a right to bail, a magistrate or judge can choose not to grant you that bail. And several things can influence the judge's decision not to grant bail. Things like the severity of the offense, things like the possibility of the accused to jump bail. Maybe one Hausa man from the north that is living under the bridge comes to Lagos, for example, and commits arson, burns somebody's property. Arson is a bailable offense, but will the court be willing to grant that person bail, knowing that there's a high chance that the person would escape, would jump bail? So there are different things that can influence a judge's refusal or acceptance to grant bail. A judge can even deny bail due to public outcry or national interest. Maybe there's a very popular fraud case and everybody's talking about it, and maybe the person that was defrauded, has fallen sick and is in the hospital. The court might be reluctant to grant bail to that fraudster, knowing that it's going to cause public outcry. So there's so many things that can inform a judge's decision to either grant or deny bail. So in this case, the judge weighed all the options and his or her lordship felt it's best to grant bail to these accused persons. So they have been granted bail to the tune of 20 million naira with sureties in like sum, sureties that are worth 20 million, and they must be gainfully employed also. So these are bail conditions. To grant bail is one thing, but bail conditions can be very stringent, and if you don't meet your bail conditions, you will remain in prison custody until you can meet it. So I'm not quite sure if they have been able to meet their bail conditions, but yes, they have been granted bail. Let me know what you think about the court granting them bail. Do you think it's okay? Do you think they would jump their bail? Do you think they would escape? This country is so porous, someone can just run from Lagos and go to Sokoto and throw away their SIM and start a new life there. Nobody will ever find them. It's not like abroad where everything is documented. Do you think that it's risky to grant them bail, or do you think that it's okay? So before we close this video, it's quite important that I bring to your notice that CHRISLAND schools have now been reopened by the government. A lot of people have been advocating for that school to be permanently closed. They wonder why one crisis after the other, one tragedy after the other has to be continuously linked to that particular school. So a lot of people have advocated that the government shut down that school for good. Well, that didn't happen, and I don't know whether that would ever happen, because the government has given CHRISLAND the license and the authority to reopen and continue their regular business. Very, very much to the shock and the chagrin of a lot of people. So according to reports, parents of CHRISLAND school, well, some parents of CHRISLAND schools have been advocating for the school to reopen. They don't believe that the school should just be on standstill because of one single event, according to how it was reported. They don't believe that everybody is supposed to suffer. Their children's academics is supposed to suffer just because of witness incidents. More particularly, are parents whose children and wards are in transitionary classes like JSS3 and SS3 that have external examinations to take. There, in collaboration with CHRISLAND schools, craves the indulgence of the government to please reopen the school so their wards can go back to school and take their examinations and their life can move on. Well, the government has indeed granted their request and reopened the school, and normal school activities are ongoing. This news was received with mixed reactions. A lot of people were quite unhappy and upset about that news. They believe that CHRISLAND schools have been in the news for so many bad reasons, and there is no need to have that school reopened. Their license should be seized permanently. They say that investigations are still ongoing. The matter is in court, so why rush to open the school? What if the school is found guilty? Why don't we wait for the court case to be over? And if they're found not guilty, then they can be reopened, not in the heat of the whole crisis. They have resumed and, everything is just going on normally as though a child didn't die in that school. While some other people believe that no, that's not the best way to go about it. You cannot just freeze somebody's investment of decades just because of that incident. Yes, the matter is in court. Let them continue with the court proceedings. The children do not need to suffer because of that incident. Changing the schools of hundreds of students just because of one person is wrong. It is their opinion that CHRISLAND schools is innocent until proven guilty, so the school should remain open for normal activities to continue. Do let me know which of these two schools of thought that you fall under. So guys, we have come to the end of today's video. There are more updates coming and I'm going to keep you up to date in subsequent videos. If you're not subscribed here, do subscribe to our YouTube channel, turn on your bell notifications, drop your comments in the comment section, give this video a big thumbs up and stay glued because we have so much more coming your way. It's me, your girl Barrister Neze, and this is Nezeville. I'll see you guys in my next one. For now, bye.